following Inuit Peace Committee, I will pass it to Chase Strangio, co-director of the ACLU's LGBT and HIV project.
Hi, everyone, and thank you, Jillian. Thank you all for joining. I just want to start first by acknowledging the incredible young people and their parents and Dr. Lacey, who were plaintiffs in this case and really put themselves out there and on the line at a time of incredible vulnerability and pain. As a parent, there truly is nothing more scary than watching your child suffer and having the government come in and displace your best judgment about medical care for your child is unimaginable to me, and it was unimaginable to them. And they stepped up and tried to fight and did fight for a more just world, not just for their children, but for all children and all people who deserve protection under the Constitution. So today, as we wrestle with the court's opinion, I just want to acknowledge them and also the incredible legal team from ACLU and Lambda Legal, ACLU of Tennessee, and Aiken Gump, who worked from March of 2023 through today, every single day, tirelessly to fight back against the increasingly devastating attacks on trans people from the government. So we start there. Obviously, the court has issued an opinion that allows Tennessee's law to remain in effect, that allows the state of play for adolescents and their families in this country to continue, wherein people are losing healthcare, moving around the country, trying to ensure that they can continue the medical treatment that they need, that their parents consent for them, and that their doctors are recommending. And we think that the court just got it absolutely wrong. And as a material matter, it's devastating for the people who are most affected. The Supreme Court's opinion held that Tennessee's law, which bans medical treatment when it's inconsistent with a person's sex, is not a sex classification or a transgender status classification warranting what the court calls heightened scrutiny under the Equal Protection Clause. We think that that is fundamentally wrong and inconsistent both with the plain language of the statute and the court's longstanding precedent. So, we certainly decry that decision as just absolutely not in line with the court's prior decisions. And obviously, it is that reasoning that is causing grave harm to our clients and to transgender young people across the country. By the same token, I think it's important to point out some of the ways that this opinion is much narrower than it could have been and then the lower court opinion was. I want to point out two things in particular, and I'm sure my colleagues will identify more. One is that unlike the lower court decision, this decision does not say whether or not Bostock applies outside the context of Title VII. The Sixth Circuit had gone out of its way to limit Bostock's reasoning to Title VII, which was inconsistent with the text of that opinion. The court here does not opine on whether it is a decision that applies outside the context of Title VII. So that's one significant way the decision is narrower than the lower court decision. The other way is that the court did not rule on whether or not transgender status independently warrants the type of heightened scrutiny that sex-based classifications also trigger. So that means lower court decisions, for example, in the Ninth and the Fourth Circuit, that have already recognized that transgender status triggers this type of heightened scrutiny will remain good law, and that government discrimination targeting transgender people, either through facial classifications or invidious discrimination, are both contexts in which the court has today explicitly left open for heightened scrutiny by the courts. And so these are ways in which we have thankfully narrowed some of the egregious aspects of the lower court opinion. But of course, the most immediate effect is on our clients and other young transgender people in Tennessee and across the country who need medical care that the government has stepped in to ban. And for them, we are devastated, and we know that we will continue fighting so that government discrimination against transgender people will end. And this is a setback in many ways, but we continue onward in the fight. And we can, hold simultaneously both the pain of this decision and all of the possibilities of the future we're building. And with that, I'll turn it over to Karen to offer further reflections on the court's opinion today.
Thanks so much, Chase. I couldn't agree more. This is in so many ways a heartbreaking ruling for transgender young people, for their families, for their providers who want nothing more than to see them live and thrive and be their fully realized selves as they navigate the world. And with the court allowing Tennessee's ban to remain in place, there's no question that it makes it harder for them to escape the danger and the trauma of being denied that ability to seek the health care that they need. But I couldn't agree more with Chase that it's very important to note the specifics of the court's ruling, which is really limited to laws that bar medical treatments for minors, where there's no evidence that the law was based on animus, where there's no argument that the bans are just a proxy for discrimination against transgender people. While, we may not agree with the way the court characterized the arguments that we made and the record that was before it, while it's hard to stomach the characterization of Tennessee's law as not engaging in sex discrimination on its face, when it bans medical treatments for adolescents assigned one sex at birth while permitting the same exact treatment for adolescents assigned a different sex at birth. I think it is really important to, again, reiterate that the Supreme Court did not endorse the entirety of the lower court's ruling. It did not mandate or even green light other bans on gender affirming medical care, even for young people, or other forms of discrimination. It really is about how it viewed Tennessee's ban in this specific way and left us plenty of tools to fight other bans on healthcare and other discriminatory actions that target transgender people, including other equal protection arguments about transgender status discrimination, about the animus-based targeting of trans people that is so rampant, both from the federal government and states across the country, arguments that are rooted in sex discrimination statutes, and parental rights arguments, which the court declined to even take up or address in any way here. So today hits hard, and we are holding our trans loved ones and our community members close. And tomorrow we continue to fight back against these craven political attacks that really deny trans people safety and dignity. And so with that, I will turn it to Lucas.
Hi everyone. I thank you for being here, and I just want to reaffirm what Chase and Karen have said already. Here in Tennessee, trans youth and their families are disappointed that I've already spoken with about the ruling, that the Supreme Court has not protected their families' rights to health care. But they are more resolved than ever to continue to stand up for their young people and their families, to ensure they're able to live happy, healthy, and successful lives. We couldn't agree more that the court got this completely wrong, that it is clearly a sex-based classification and transgender-based classification on the face of the law. But the fact that it's a narrow ruling, it means that we will continue to fight and stand with trans people and their families in Tennessee, with all the tools at our disposal, to continue to stand against the assault from the government of Tennessee on trans people.
Thank you, Lucas, Karen, and Chase. With that, we will take your questions. You can ask questions by either raising your hand, your virtual hand, and I will select you and you will come off mute to ask your question to the panel, or you may type it directly into the Q&A option at the bottom of your Zoom screen. First up in the queue, I see Orion Rumler from the 19th.
Thanks so much, y'all, for doing this. Chase, I saw on Instagram you said in response to this ruling that the court left open many avenues for your teams, or LGBTQ rights lawyers more broadly, to keep fighting. What are those avenues that y'all are considering at this time, which is pretty early after the ruling, but wanted to know more about that? Thank you.
Yeah, so I guess it depends on the context, but because of the ways in which the opinion is much narrower than the lower court opinions, I would say first with respect to ongoing litigation by LGBT groups against the Trump administration, every single one of those cases has both an independent basis outside of equal protection to continue. And then also the court was very clear that it was addressing this particular type of classification in the context of minors. And so the other contexts in which we're litigating, even under the Equal Protection Clause, I think remain open to arguments under heightened scrutiny. So that's one aspect doctrinally that will remain open. There's also the trans status arguments. There are other types of government discrimination against transgender people where we have and will continue to advance arguments that they discriminate on their face or by their intent against transgender people, warranting heightened scrutiny, both because they are based on animus, which the court clearly inexplicitly left open as an avenue for arguing under the Equal Protection Clause, and then also arguing that transgender status is a quasi-suspect classification. So all of that will, of course, continue. And then the litigation that we have ongoing in state court will also continue, unaffected by the ruling here, because a lot of those cases are based on independent state constitutional theories. I don't know, Karen, Lucas, if you want to add to that. And then I guess the other thing to say is several of the cases below also continue to have the parental rights claims that were not resolved. I know Karen was betting. I saw Karen's face and I knew that I forgot that, obviously the court didn't even take up that question. And that question is before not only the circuit courts, but some of the district courts. And so, we continue to litigate under every theory that we have.
I think the other thing that I was going to add, both sort of specifically to these constitutional theories, but also sort of to the other tools in our tool belt, is that, this decision is rooted in how the court saw the record below, right? Like this is very specific in terms of what the record showed, around the status of the healthcare and whether there was animus present and whether, there were other things that would suggest that a law is about something more than just pure discrimination. And frankly, different records show different things, particularly on that front. I think particularly around some of the executive branch action that we're seeing at the federal level, courts in lots of contexts have already found that some of those actions are just plainly rooted in animus, in ways that really distinguish what's happening here. The other thing that I'd mention, of course, is that there are also statutory theories that might apply in different contexts related to healthcare. And by not sort of cabining Bostock to the employment context, as Tennessee had argued, and that the lower court essentially found, those paths are still really viable for recognizing the denials of healthcare to trans people are still statutory forms of sex discrimination.
Thank you both. Let's go to Kenya Hunter for the Associated Press.
Hi, thanks so much for taking the time. I'm wondering how many of these challenges are rooted in state constitutions. I know that we've named a few, like Montana and Arkansas, but I wonder just how many of these, because I hear you all saying that this really only applies in Tennessee. So I'm just curious to know how many challenges are actually rooted in state constitutions with these bans.
So I guess the question is, there's sort of maybe two ways to think of this: which theories may continue in federal court, and then what cases are continuing under state constitutional theories. There's the Montana case, which is under Montana's constitution. There's a case in Kansas under Kansas's constitution. I believe that there may be some forthcoming cases under other state constitutions. There's ongoing litigation in Ohio under the Ohio Constitution, including, idiosyncratic provisions of these constitutions that don't have federal analogs. And then there's the reality that, to Karen's point, that some of the cases that are still pending in federal court are not going to look exactly like Tennessee's statute. So they may also continue. It sort of remains to be seen, because those are independent cases with independent records and different statutes, including some cases that have, adult restrictions on top of restrictions for minors. And the court was very clear to talk about how this was about care for minors.
Thank you. I appreciate that. And then I'm also curious to know, when it comes to adult versus children. I mean, I think I'm wondering, just how do you all see this impacting? I know this is about children, but how do you all see this impacting just gender affirming care in the future for all people, adults and children?
I mean, I would start where Chase just left off, which is that this decision is very clear around the age factor being very central to this opinion. The failure to sort of recognize the sex discrimination inherent on the face of this law is concerning. There's no question about that. But I think the court here went out of its way to really confine what it was doing here to a restriction on care for minors. Again, there's that additional piece of what is this law actually trying to accomplish, and when it is the targeting of trans people for disfavored governmental treatment, and for adults in particular, that's a very different set of justifications that the state's going to have to come up with. I don't think that this precludes challenges that will be incredibly successful to any actions against adults trying to access gender affirming medical care.
And related to that, and I think this goes to Arvin's questions in the chat. I mean, obviously, to Karen's point, that it is wrong and concerning that they look at Tennessee statute and say that's not a sex-based classification. It was concerning when in Dobbs they held that the equal protection part of Godoldig was in essence reaffirmed. So there's all sorts of ways that I think we are concerned about the context of medical care when it comes to the court's analysis. And at the same time, the reasoning here is very much tied to the record in the case and how they're interpreting that to make a determination that the classification is based on medical purpose and age. And so that, if you take, for example, something like the president's executive order with respect to medical care, that does not even that, which is for minors, does not talk about the underlying concerns about the medical care. It talks about gender ideology. That would be considered differently from the record that was before the court in this case. Additionally, when a government policy might single out transgender people on its face of all ages, then it's no longer an age classification, and that would impact the court's analysis under the ways in which they made clear to cabin the reasoning here to both the age and medical purpose factor that were very much grounded in the way in which Tennessee's statutory findings, legislative findings, and language was put forth in this context. Now, we think that was wrong. We disagree, but I don't think it should be interpreted to mean that the court is foreclosing future challenges to broader attacks on trans people's healthcare. That said, we're in a moment in this country where transgender people are under attack in lawless ways, in violation of state law, in other ways, and we know that is going to continue. And so we are remaining vigilant and ready to fight back with every tool that we have.
Thank you so much. I appreciate your time.
Thank you, Kenya. And Erin, your question is very much along those lines in the chat. If that doesn't answer it, feel free to ask a clarifying question or follow up. Christopher Kane from the Washington Blade.
Hi, thanks so much for doing this and for taking my question as well. Wondering, either in the opinions that were issued today or in the course of oral argument, I wonder if there was discussion among the justices of the harms that can result from interrupting care for minors who are currently being treated for gender dysphoria.
Well, so it was certainly part of our extensive briefing, and we tried to introduce it at argument. I think one of the frustrating things about the type of deference that this court found would apply here is that they don't really look at the underlying evidence, and so they can just sort of defer broadly and uncritically to state legislatures or legislatures more generally. And so that did not figure in the majority opinions in the ways that we all wished that it would have. Certainly the dissents did address that, and we know how devastating it is for people to lose access to medically necessary care, to lose access to this healthcare. And when the first of these bans passed in Arkansas in 2021, for all of us who have done this work for our entire lives, it was an unimaginable escalation to think of people losing this care so suddenly and so aggressively. And yet that's where we find ourselves today. And the court was very insistent, I think, on not addressing that.
And I would just lift up, Justice Sotomayor's dissent in as much as her questioning of Tennessee's attorneys during argument, right, was a recognition of the real harms to our actual clients. And her dissent really talks about what it meant before our clients had access to the gender affirming medical care that they needed, and the real harm of that now being unavailable to them. So, there was definitely some recognition during the discussion, during argument, of what this really means for trans young people. And, it was clearly not part of the calculus that the majority was willing to really consider.
Thank you, Christopher. Going to Trudy Ring from The Advocate.
Hi, thanks for all being here today. I was talking to Jennifer Levi of GLAAD today, and she said she did not think this would lead liberal states to try to enact bans. She said it's very much a country divided. Do you folks agree with that or not?
I'll say I agree with it. Like I said earlier, there is nothing in this opinion that is a mandate. There's nothing in this opinion that is a green light for others to join the bandwagon here of discriminating against trans young people. So I think we've seen through briefing, through policies enacted, there are plenty of states who recognize the medical necessity of this care and continue to make it lawful and available.
Yeah, I completely agree.
Okay. And if I could ask one follow-up, when you say how much narrower this is than the lower court, I guess the trial court decision, could you I can go back and look at the decision, but if you can elaborate on the ways that it's narrower?
Yeah, so I think that so one way it's narrower is that it does not limit Bostock to Title VII, whereas the lower court's decision did. That's especially relevant in the healthcare context, as Karen pointed out, because there are other statutory protections. And so by not opining unnecessarily on the applicability of Bostock outside the context of employment and Title VII, that leaves open other avenues for continuing to argue Title IX claims, of 1557 claims, for example. It also does not address the question of whether discrimination that courts find is based on transgender status. It is a quasi-suspect classification. So in contexts where a law says and a court believes the law says that transgender people can't do something because they are transgender, the court left open the possibility that that would trigger heightened scrutiny, both because transgender status is a quasi-suspect classification, as the Fourth and Ninth Circuits have already held, or because it is based on invidious discrimination. So there's those avenues for arguing against government discrimination remain open. And I think those are pretty significant differences from the Sixth Circuit's opinion, which had foreclosed both things.
I would also add that also recognizes that other kinds of sex-based classifications may in fact be discrimination warranting heightened scrutiny where they are in fact about trans status, right? That trans status is independently warranting heightened scrutiny, but that that sometimes discrimination against trans people is also a form of sex discrimination. So again, I think this opinion is much more cabined to this particular law, this particular kind of law, and the absence of other kinds of sex-based discrimination that might be present. So, you know, it really, the Sixth Circuit was like, there was no sex-based discrimination of any kind here under any theory whatsoever. And I think what the Supreme Court issued here is narrower than that.
Okay, thank you. And Jillian, I would like to receive the recording, but I can send you an email on that too.
Yes, please send an email because we'll need to, that will stick in my memory better than a
Okay,
verbal
I'm
reminder. But I
sure.
hear you. Evan Mullins from the Tennessean.
Hi. I think there are obviously a lot of young people in Tennessee and in other states who were hoping for a different ruling. What is available to people who were seeking gender affirming care, young people who were seeking gender affirming care, um, in states with a ban? Like, what would you say to them in terms of getting help or other resources that are available? Does that make sense?
Yeah, so this is Lucas. I would say that you know, unfortunately in Tennessee, this law forecloses a lot of the medical care that would be available to them. So luckily, our clients and a lot of trans youth in Tennessee have supportive families and have the privilege and ability to be able to take time off work and school to be able to go out of state to obtain medical care. But so many other young people do not, or do not have families that support them to try to assist them in getting that care from out of state. But the law in Tennessee forecloses a lot of medical care. It does not say that young people cannot receive you know, go to counseling or psychologists, which unfortunately is not in many cases not enough medical support to really um, uh, help these young people with their gender dysphoria. And the legislature in Tennessee seemed to indicate during a lot of the hearings and testimony on the bill before it was passed into law that they believe that perhaps psychological counseling in the form of trying to get transgender young people to accept the sex they were identified as birth rather than to continue on a path into accepting themselves as transgender and affirming their gender identity was what the state of Tennessee would really like to see. So they left open that avenue. And unfortunately, I think could be used for a lot of really harmful kind of psychological interventions. But otherwise, they do not have access to any kind of medical treatment that could support them in their gender affirming care.
Thanks, Lucas. What I would add is, you know, I think as in so many instances, the barriers to accessing care are higher for the folks who have the least resources. And I think we need to recognize that young people who are in state custody in some way, shape, or form, who are in juvenile justice settings, who are in the child welfare system, folks who are getting their healthcare through Medicaid, who have the least sort of financial resources, are the folks for whom the barriers to accessing care are the highest. And, you know, it is absolutely true that care remains lawful in many states across the country, and we hope that young people will be able to access that care where it is lawful. And we also know that for many young people today, this feels particularly hard when they know that that lawful care is out of reach for them.
And just to add, that unfortunately that has been true for the last 2 years, and that, you know, people who need this care have been suffering when they can't get it, and it's usually the people who don't have the resources to be able to travel, to miss work, and that the people who have those resources have had to travel many distances, have often had to go from state to state to state. So unfortunately, this decision doesn't provide a reprieve from that. But people will continue fighting for the care that their kids need.
Thanks, y'all.
Lawrence Hurley from NBC News.
Hi, can you hear me?
Yep, we can hear you, Lawrence.
So, by my count, there are 3 justices who didn't tip their hand on where they sort of might fall on heightened scrutiny if they ever do reach that. And three, and they're all conservatives who didn't say anything. So, what are how hopeful are you that in a future case you can get at least 2 of those 3 votes? And can you also talk a bit about what that next future case could be? I know there's various things pending, including the transgender military ban and sports cases and things like that. But what are some of the issues kind of bubbling up, and what could be the next case?
So I guess first, with respect to whether we could get 2 additional justices on the question of transgender status independently triggering heightened scrutiny, I think the most immediate question is whether the lower courts will continue to be able to apply it and enjoin unlawful discrimination against transgender people, which as of now they will be able to do. And there may be another case in any of the contexts where that comes up. There are cert petitions sitting at the court right now in the sports cases where these questions are presented. So we just don't have control over how these issues necessarily reach the court. But there are myriad examples of discrimination against transgender people by the government making their way through the lower courts. Other examples of healthcare discrimination, obviously, the various examples of discrimination by the administration with respect to identification, healthcare for people under the age of 19, the military bans, restroom exclusions in public buildings. So these issues are still percolating, and advocates don't have control always of when and how they reach the Supreme Court. But the lower court decisions applying heightened scrutiny to transgender status still stand. And so injunctions that are either currently in place or may be in place in the future on that basis remain good law.
Thank you.
Ryan, I see you, but I want to jump to some questions in the chat since you had a question earlier, but I will come back to you. Maureen Gropp from USA Today asked, what does the decision mean for other cases about bathroom sports, military service bans, etc.? But obviously that could be a broad question, and perhaps we've already touched on that.
Yeah, I mean, I would say just, going back to something Karen said earlier, the court was really clear that they were analyzing this particular type of classification in this particular context. When it comes to restrooms and sports, the parties generally agree that those are sex-based classifications triggering heightened scrutiny. So it's just a completely distinct analytical question other than the trans status question, which the court didn't resolve here. And then similarly with the military, there's a whole separate set of deference doctrine that the Supreme Court and the lower courts apply in that context. But again, I don't think they are directly resolved by the analysis here in Scrimetti. So the litigation will continue, both because the type of classification is different and because the state justifications for the discrimination are different. So the court will have to grapple with them independently.
Yes, I think I totally agree with all of that. And as frustrating an answer as it is, I don't actually think this tells us much at all about how those other contexts will proceed before this court. So in as much as I think we try to read tea leaves and find doctrinal through lines, this is one of those instances where the court made clear that they were just doing something different and specific here. So we will continue to fight those in all the ways that we have done in the past.
Daniel Smith, and I'm looking to Lucas for this question. Moving forward, what happens now with families? Will they stay in Tennessee or move to another state that has gender-affirming care for minors? Lucas, I know you said you've already spoken with some families, perhaps some of our plaintiffs, but just generally, what are you hearing from families in Tennessee?
Yeah, sure. Generally, families in Tennessee, many of them are discussing potentially moving out of the state or moving out of the country, just based on what's been happening in Tennessee as well as, throughout the United States, with a lot of the executive orders that are aimed at trans people. Many families in Tennessee are able to go out of state to obtain care, like I had mentioned before. But unfortunately, many do not have the resource to do that, because they have to take off many times days of work and days of school, which then not only on paying for the cost of care, they are then, taking days off work that they potentially do not get reimbursed for, and then having to pay for plane tickets or gasoline, hundreds of miles out of state, and potentially having their young people have to miss, a day of school, which is just, it's really hard on them. And so many families already have moved out of state, and I think many are still considering doing that or even potentially out of the country.
And then Sophie Hills from Christian Science Monitor, asking for clarification on something Chase said about other examples of discrimination against transgender people, or the decision holding that other examples of discrimination against trans people are unlawful. Could you share some of those examples?
I don't think I said that the decision says other examples are unlawful. I wish that were the case in general, but the Supreme Court won't opine on other contexts outside the direct context before them. I think the relevant point is the court left open the possibility that heightened scrutiny would apply in a range of other contexts. And there are lower court decisions that, for example, have already held that transgender status triggers heightened scrutiny. Karnofsky in the Ninth Circuit, Grimm in the Fourth Circuit. And so that, I think that was maybe what that was referring to, or even the court sort of identifying other types of line drawing that would be sex-based outside the medical context. So clothing inconsistent with sex. And so that, sort of making clear that this is very much limited to the direct context before it and not actually resolving these other questions, and making clear that those other contexts either definitely do or likely would trigger heightened scrutiny.
And then lastly, back to Ryan Rumler at the 19th.
Thanks so much, y'all. I was curious, the court also seems to be framing Tennessee's law as one that removes a diagnosis of gender dysphoria from allowed treatable conditions. I thought that was interesting when they're talking about the way they're separating minors into two groups, like those seeking puberty blockers or hormones to treat the excluded diagnoses, or seeking that care to treat other conditions. Do y'all see a route forward to challenging gender-affirming care bans by looking to disability law or challenging them on the basis of disability discrimination, since that aspect is being framed as withholding care based on a medical diagnosis? Just curious if y'all are thinking about that. Thank you.
So there is at least one circuit that has held that discrimination based on gender dysphoria it falls within prohibited disability discrimination under federal statutory prohibitions. And so that is definitely one litigation strategy that remains open. But obviously, as a constitutional matter, it wouldn't change the level of scrutiny, because in Cleburne, the court held that discrimination based on disability also gets rational basis. And that's just another part of the opinion that's totally wrong, because in fact, Tennessee statute doesn't make any reference to gender dysphoria, and it hinges its prohibition on sex inconsistency. But yes, analytically, there are cases pending in the lower courts arguing disability discrimination under federal statutes and state statutes in some contexts.
Thank you so much.
With that, there are no more questions in the chat or in the queue. One more from, oh, never mind. I'm gonna, Brett, do you want to end us on one last question? Brett Rains?
Please, I'm so sorry. I just joined, jumped on right before you guys wrapped up. I know you'll have to repeat it, but can you please give me just overall go through so I can get general reaction to this latest ruling and what that means for many states?
You know, Brett, I'm going to send you the full recording of the press call, and I should include that in the advisory that a recording would be made available. So you'll have the opening comments summarizing the ruling and the responses to all the questions that were asked. If that's okay for you. All right, so with that, thank you all so much for making the time today. Thank you to Chase, Karen, and Lucas, our friends at Lambda Legal and the ACLU of Tennessee. As I noted, a recording will be made available. Feel free to reach out to us if you have any further questions about this ruling or any of our other advocacy work. You can contact us at media@aclu.org or Lambda Legal at media@lambdalegal.org. And thank you all so much and enjoy the rest of your day.